Right, I welcome members to the 22nd meeting in 2013 of the Delegated Powers and Law Reform Committee. As always, ask members to turn off mobile phones and any other electronic equipment. It's proposed under Agenda Item 1 that the committee takes items 7 and 8 in private. Item 7 is consideration of a draft report on the delegated powers contained in the Tribunal Scotland Bill at Stage 1. And item 8 is consideration of the committee's approach to its scrutiny of the Marriage and Civil Partnership Scotland Bill at Stage 1. Do members agree to take items 7 and 8 in private, please?
Agreed.
Yep. Agenda item 2, instruments subject to affirmative procedure. The Rosyth International Container Terminal Harbour Revision Order 2013 draft. Members have before them written submissions which the committee has received in relation to this instrument. Do members have any comments, please? No? Okay, no points have been raised by our legal advisors. Is the committee thereby content with the instrument, please?
Content.
Yeah. Okay, thank you. That deals with that. Agenda item 3 is instrument subject to negative procedure. The Council Tax Reduction Scotland Amendment number 2 Regulations 2013 SSI 2013-218 and the Council Tax Reduction Scotland Amendment number 3 Regulations 2013 SSI 2013-239. In relation to the number 2 regulations, Regulation 9 appears to be defectively drafted, as it provides that the Council Tax Reduction Scotland Regulations 2012 are amended in accordance with Regulations 10 to 16, when the intention is to so amend the Council Tax Reduction State Pension Credit Scotland Regulations 2012. The Scottish Government has acknowledged this error. It's laid the Council Tax Reduction Scotland Amendment number 3 Regulations 2013 on the 9th of August to correct it in time for the coming into force of these regulations on the 1st of October 2013. Does the committee agree to draw the instrument to the attention of the Parliament on reporting ground I, as Regulation 9 appears to be defectively drafted?
Agreed.
With regard to both sets of regulations, SSI 2013-218 and 2013-239, our legal advisors have suggested that the regulations raise a question of whether they relate to matters which are reserved by Section F1 of Part 2 of Schedule 5 to the Scotland Act 1998, and as such the committee may wish to report the regulations as raising a devolution issue. The matter was also raised in connection with the Council Tax Reduction Scotland Amendment Regulations 2013, SSI 2013-48, the Council Tax Reduction State Pension Credit Scotland Amendment Regulations 2013, SSI 2013-49, and the Welfare Reform Consequential Amendment Scotland Number 3 Regulations 2013, SSI 2013-142, all of which the committee has previously considered. As members will recall, the Scottish Government's view is that the principal regulations do not relate to any of the reserve matters described in Section F1 of Part 2 of Schedule 5 of the Scotland Act. When the committee considered the principal regulations and the amending regulations, a majority of the committee members preferred the Scottish Government's view. It is, of course, for the committee to decide whether it wishes to report the instrument or whether, as with the previous regulations and the other amending regulations, it is content that no devolution issue has been raised. Do members have any comments, please? Let me start with John, if I may.
I believe that we should report these instruments on the grounds that they may not be within virus as they appear to relate to matters which are reserved by Section F1 and Part 2 of Schedule 5 of the Scotland Act. As before, I believe we should take the legal advice and report these.
Thank you very much. Stuart.
The reason that we are advised that this may be ultra vires is, of course, based on the idea that a reduction in a charge should be identified as a benefit, which would be reserved. But of course, if that were to be the case, a wide range of other sources of reduction in charges, particularly in reduction in council charges, would have to also be deemed ultra vires. I give as examples the reduction in a council tax charge when there is a single person in a property. I give as a further example reductions that relate to second properties. It is clear that Parliament and the lack of any challenge to these reductions on the basis that they are a benefit is equally applicable in this particular case. And I will continue to adhere to the view that the reduction in a charge is not, in law, a benefit, and therefore I would not wish this committee to report this to Parliament.
Okay, Mike.
Can I ask if perhaps our advisors are able to confirm whether or not the Westminster Government have commented on the issues raised here under this kind of suite of related proposals which the committee have previously considered?
You could certainly ask. Come.
Yes, we've had no intimation from the Westminster Government in relation to this suite of instruments.
Okay, thank you. Are there any other comments, John?
Yeah, I would probably tend to agree with Mr Scott that with the view it's been taken in the position that we took previously. And even though that, you know, when you look at the report and there's not been any, you know, challenge to the in the past, I'm still not convinced that, you know, our legal advisors are wrong in this one. Yeah. So to be consistent, you know, we will ask that this be referred.
Okay. John?
I would just say that because there hasn't thus far been a legal challenge doesn't mean that there won't be one in future.
I entirely accept that. Right, I think we've rehearsed the ground, and I understand why we've done that. I would just suggest that in the interest of consistency, we would probably want to stick to what we've done before. Anyway, there being very little point in being inconsistent about it, but nonetheless I recognise where colleagues are coming from. On that basis, and on the basis that it appears that nobody else has anything else to say, I would like simply to suggest the proposition to the committee is that the committee considers that the regulations are intra vires and should not be drawn to the attention of the Parliament. Are we agreed?
No.
Okay, we therefore divide on that issue. With those who support my proposition, please indicate. Thank you. Happy? 4. Those against? Thank you. Again. Right, on the basis that there are 4 for and 3 against, the proposition is passed and the regulations will not be reported. Thank you for that swift and agreeable discussion. Turning now to the specified products from China restriction on first placing on the market, Scotland Amendment Regulations 2013, SSI 2013-221. There's been a failure to lay the instrument at least 28 days before it comes into force, as required by Section 28.2 of the Interpretation and Legislative Reform Scotland Act 2010. The Scottish Government has explained that the breach of the rule was necessary to ensure that the continued integrity of the feed and food chain to prevent products containing unauthorised genetically modified race from being placed on the market in Scotland, and in order to comply with EU requirements. Accordingly, the committee may wish to be content with the explanation provided. Does the committee agree to draw the instrument to the attention of the Parliament under reporting ground J, as there has been a failure to comply with the 28-day rule?
Agreed.
Does the committee also agree to find the explanation given by the Scottish Government for the failure to lay the instrument at least 28 days before it comes into force to be acceptable?
Agreed.
Okay. The Landfill Scotland Amendment Regulations 2013, SSI 2013-222. There has been a failure to comply with the 28-day rule in relation to this instrument also. Committee may consider that better advanced planning of these regulations could have avoided this breach, taking into account that Directive 2011-97 EU implemented by the regulations was published in the Official Journal in December 2011 and provided until the 15th of March 2013 for implementation. The Scottish Government has explained to the committee that the timings of the implementation of the directive and the chosen date of laying this instrument in advance of that date when it comes into force have been considered to be an example of appropriate prioritisation of legislation. In view of the timescale for proper implementation of the directive from December 2011 to March 2013, the committee may find that explanation to be unsatisfactory. Does the committee agree to draw the instrument to the attention of the Parliament under reporting ground J, as there has been a failure to comply with the 28-day rule? Please, just the question.
Agree.
We do, thank you. Does the committee also wish to note the Scottish Government's explanation?
Thank you, Convener. I think it is appropriate we draw this to the government, as report to Parliament, as we've agreed to do. But in doing so, I think while recognising that there is no practical environmental effect one way or the other through the passing of this regulation, because it applies to an activity that does not and is not expected to take place in Scotland, it nonetheless raises a wider issue in that it appears to be out with the timescale that would be required under European law. And I think that the government perhaps may wish to take note of the committee's remarks in that regard, and would wish to see, unless there is a more substantial reason other than simply resourcing and administrative convenience, for going outside what is required under European law. In this case, the practical effect is no, that's fine, but I think there is a point of principle here.
Indeed. John.
I would like to agree with
Mr. Stevenson. I don't think it's appropriate for the government to decide that it is appropriate to break a 28-day rule knowingly and without good reason, given the amount of time that there was available to comply with it.
Does the committee therefore wish to draw to the Scottish Government, does the committee want to draw the Scottish Government's explanation to the for the breach of the 28-day rule to the lead committee?
Yes.
That's the appropriate way of dealing with that. Thank you very much. Hans-on.
Scope for an explanation, because you will recall that I've made comments on this in the past as well in regards to them slipping time, and clearly there seems to be a management issue, and by asking an explanation it may focus people's minds in trying to ensure that they can give the appropriate support wherever it's needed to make sure that it doesn't happen in the future.
Indeed.
I think this just continuously having people slipping time and just accepting it is a bad practice.
Indeed. John.
A slightly different subject. I would note that the government has agreed to consider consolidation, and I would welcome that.
Yes.
I'm sure other colleagues might welcome that too, given that the regulations have been amended 9 times. To try and finish this discussion on a positive note.
Indeed. I mean, and I take it that members would want to welcome that. I think that is one of the issues we've raised many times, and it would be good to see that. Indeed. Thank you. Turning now to the football banning orders, regulated football matches, Scotland Order 2013, SSI 2013-228. There has been a failure to comply with the 28-day rule. However, the committee may wish to be content with the breach of the rule was necessary to update the definition of regulated football matches contained in section 55.3 of the Police Public Order and Criminal Justice Scotland Act 2006 to include pre-season football matches where one or both of the participating teams represents a club which is a member of the Scottish Professional Football League. The committee may therefore wish to be content with the explanation provided by the government. Does the committee agree to draw the instrument to the attention of the Parliament under reporting ground J, as there has been a failure to comply with the 28-day rule?
Agreed.
Does the committee also agree to find the explanation given by the Scottish Government for the failure to lay the instrument with at least 28 days before it comes into force to be acceptable?
Agreed.
Thank you. Sports grounds and sporting events designation Scotland Amendment Regulations number 2 Order 2013 SSI 2013-229. There has again been a failure to comply with the 28-day rule. However, the committee may wish to be content that the breach of the rule was necessary to bring the order into force to ensure that pre-season football matches played by members of the Scottish Professional Football League were subject to the terms of the Sports Grounds and Sporting Events designation Scotland Order 2010, as they would have been prior to the change of the league name. The committee may therefore wish to be content with the explanation provided by the Scottish Government. Does the committee agree to draw the instrument to the attention of the Parliament under reporting ground J, as there has been a failure to comply with the 28-day rule?
Agreed.
Does the committee also agree to find the explanation given by the Scottish Government to be acceptable?
Agreed.
Thank you very much. No points have been raised by our legal advisers on the Public Health etc. Scotland Act 2008, Sunbed Amendment Regulations 2013, SSI 2013-201, nor on the sale of tobacco, Prescribed Documents Scotland Regulations 2013, SSI 2013-202, nor on the vulnerable witnesses giving evidence in relation to the determination of children's hearings grounds, authentication of prior statements, Scotland Regulations 2013, SSI 2013-215, nor on the contaminants in food, Scotland Regulations 2013, SSI 2013-217. Is the committee content with these instruments, please? Thank you. Turning to agenda item 4, instruments not subject to any parliamentary procedure. No points have been raised by our legal advisers on the Criminal Justice and Licensing Scotland Act 2010, Commencement number 11 and Saving Provision Order 2013, SSI 2013-214. Is the committee content with that instrument? Content. Thank you. Turning now to agenda item 5, the Public Bodies Joint Working Scotland Bill. The purpose of this item is for the committee to consider the delegated powers in the Public Bodies Joint Working Scotland Bill at stage 1. In considering the bill, the committee is invited to agree the questions it wishes to raise with the Scottish Government on the delegated powers in the bill. It's suggested that these questions are raised in written correspondence. The responses received will help to inform a draft report on the bill which the committee will consider at a later date. Section 1.3e provides for the power to prescribe by regulations information about such matters as may be prescribed for inclusion in an integration plan. In relation to section 1.3e, does the committee agree to ask the following questions? To provide some examples of the information and matters that could be prescribed for inclusion in an integration plan, and also to ask why the power is drawn to permit any matters to be prescribed about which prescribed information would need to be included in a plan, without provision that such matters should relate to the matters which the plan will set out in accordance with section 1.3a to d. The regulations under sections 1.6a and b are intended to prescribe the range of functions of local authorities and health boards which either must, may or may not be delegated under an integration plan. Does the committee agree to ask the Scottish Government to explain, therefore, why it is appropriate that section 1.6 provides that Scottish ministers have a discretion rather than a requirement to make these regulations? Section 56 of the Local Government Scotland Act 1973 is not expressly amended by or referred to in the bill. Subsections 6 and 6a of that section provide that a local authority's function with respect to setting amounts of council tax, borrowing money, approving annual investment strategies or reports, and determining applications for planning permission for certain classes of property shall be discharged only by that authority. By subsection 7, a local authority shall not make arrangements for the discharge of any of their functions under the Animal Health Act 1981 by any other local authority. Section 1 does not provide for any exclusion of these significant functions in the 1973 Act from the powers to prescribe the functions which may be delegated in terms of an integration plan and agreed to be set out in a plan. Does the committee agree to ask the Scottish Government to confirm in relation to the scope of the powers, therefore, whether there is any intention to effect the operation of sections 56, 6a and 7 of the 1973 Act, and if not, would amendment to the bill at stage 2 be proposed so that integration functions could never extend to those functions? The committee may consider that paragraph 12 of the Delegated Powers Memorandum has not explained satisfactorily why the negative procedure rather than the affirmative procedure or a super-affirmative procedure is a more appropriate level of scrutiny of the powers in section 1.6. The powers are very significant, as the regulations will provide for a range of functions which must, may or may not be delegated under the integration plan. Does the committee agree to ask the Scottish Government to explain this further? Section 12.1 provides that the Scottish Ministers may by order make provision under various aspects of joint integration boards. Provision about various aspects of joint integration boards. Does the committee agree to ask the Scottish Government why this power needs to be drawn widely to permit any provisions by order about and so to determine the membership of integration joint boards? Why could this power not be drawn more narrowly to contain provision for the permissible number of members of a joint board, for instance stating a minimum or maximum number of members within which parameters an order could specify the number of members of a particular board, and B, contain provision for who may be a member, given that any joint boards will be public authorities which will either undertake or direct the carrying out of functions delegated by the constituent local authorities and health boards. Section 12.3 provides that the Scottish Ministers may, by scheme, make provisions under the transfer to an integration joint board of staff, property, rights, liabilities or obligations of a local authority or a health board. The Delegated Powers Memorandum explains that, as a matter of policy, it is envisaged that any integration joint board established under the bill will not necessarily require to employ staff. The delivery of functions is likely to be carried out by the constituent local authorities and health board, and the option of direct employment of staff by a joint board is included as a safeguard if locally agreed arrangements fail to work. Does the committee agree to ask the Scottish Government to explain the reasons for taking this power and explain the circumstances under which this power might be used to transfer staff, property, etc. to an integration joint board? To explain why it's necessary for this power to include the transfer of property, rights, liabilities or obligations, as well as staff, when the similar power proposed in section 15 in relation to the other integration models between a local authority and a health board is restricted to the transfer of staff, and to explain why it has been considered appropriate that the exercise of this power should not be subject to parliamentary scrutiny, nor provision made for publication of a scheme, nor that it should be made in the form of a Scottish statutory instrument.
Great.
Thank you. Section 15 provides for a power of ministers to make a scheme for the transfer of staff from a person who is to delegate functions under the possible integration models between local authorities and health boards, except for the corporate body model. Does the committee agree to ask the Scottish Government to explain the reasons for taking this power and to explain the circumstances in which the power might be used to transfer staff between a local authority and a health board, and to explain why it has been considered appropriate that the exercise of this power should not be subject to parliamentary scrutiny, nor provision made for publication of a scheme, nor that it should be made in the form of a statutory instrument?
Great.
Section 16.1 provides that the Scottish Ministers may by order make provision about the establishment of, membership of and proceedings of integration joint monitoring committees and any other matter relating to the operation of integration joint monitoring committees that Scottish Ministers think fit. Does the committee agree to ask the Scottish Government why this power need be drawn so widely, to permit any provision by order about and so to determine the membership of integration joint monitoring committees? Why could this power not be drawn more narrowly to A, contain provision for the permissible number of members of such a committee, for instance stating a minimum or maximum number of members within which parameters any order could specify the number of members to a particular committee, and B, contain provision for who may be a member, given that any such committees will be public authorities which will monitor the carrying out of integration functions for the area of a local authority.
Great.
Section 22(1)A enables integration joint boards to direct the local authorities or the health board that have delegated functions to it in accordance with an integration plan to carry out a function on its behalf. Section 22(1)B enables the local authority or health board which has had functions delegated to it in accordance with an integration plan to direct the local authority or health board which delegated the function to it to carry out the functions on its behalf. In relation to the power to make directions under section 22(1) to 7, does the committee agree to ask the Scottish Government to explain the reasons for taking them and the circumstances in which directions could be used, to explain why it has been considered that the powers are appropriate to be exercised in the form of written directions rather than the form of subordinate legislation such as an order, and whether it is intended that directions would be published on being made, and if so, should this be provided for?
Great.
Section 36(3) provides that in consequence of the replacement of an integration plan by a new plan, Scottish Ministers may, by scheme, make such provision about the transfer of staff, property, rights, liabilities or obligations of an integration joint board, a local authority or a health board as they consider necessary. Does the committee agree to ask the Scottish Government to explain the reasons for taking this power and explain the circumstances in which the power might be used to transfer staff, property, etc. upon a new integration plan being substituted under section 35? why it has been considered appropriate the exercise of this power should not be subject to parliamentary scrutiny, nor provision made for the publication of a scheme, nor that it should be made in the form of a Scottish statutory instrument. Why does section 19 apply where by virtue of section 12.3 or 15.1 a scheme is made for staff transfer to set out the effects on contracts of employment, but section 19 does not provide that it applies when this power is in section 36.3 is exercised? And to explain why it is considered appropriate that the power in section 15 enables schemes about the transfer of staff only when an integration plan sets out in one of the 3 integration models, apart from the model where an integration joint board is established, and yet this power in section 36.3 extends to making provision about transfer of staff, property, rights, liabilities or obligations when a new integration plan setting out one of these models is substituted under section 36.
Agree.
That was a question. And I'm just going to... Section 39.2a to e lists 5 default powers which the ministers may exercise, where a local authority and a health board fail before the day prescribed under section 7 to submit an integration plan for approval by them. It appears that the functions of a local authority and a health board, which may be specified under section 39.2a on default to be delegated to an integration joint board, are not limited by the prescription of functions by regulations under sections 1.6. Section 1.6 relates to the prescription of functions which may, must or may not be delegated under an integration plan. Section 39.2 applies where such a plan has not been submitted for approval. Does the committee therefore agree to seek clarification from the Scottish Government as to whether this is the intended position? That's all.
One of the things that I'm interested to know is why only the health board with local authorities, why not local authorities with local authorities as well?
That's an extremely good question. Yes, my advice is it's a very interesting question, but it's a question for the lead committee. It is actually, at the end of the day, a policy question, isn't it? There's no delegated powers in that question. So I think I need to encourage you to get that asked of the lead committee.
Can I not ask it here?
Simply because it's probably not within our powers to put it...
No, we're asking a series of questions, and I'm just wondering why are we limiting ourselves to the National Health Service? And why not other local authorities?
Yeah.
I'd be grateful if this committee would do that, because then it means, we're just simply asking a question that there's perhaps an opportunity that we've not explored.
Yeah. I think there may be a fair question, and let's just take other comments. Stuart.
Well, I'm just making... if the member would perhaps explain this a little further, because I'm really not sure that I understand what the question that's being asked is. If I'm hearing that why are there not delegated powers to allow local authorities to create joint authorities, I suspect I know the answer because the powers already exist. But I'm not sure if that's the question that's being asked. So,
well, I think
I find it difficult to take a position because I'm not quite sure.
I think that's the question as I hear it. I think what Hans Saller is asking is why we're talking about the integration of local authorities and health boards, which are contiguous before they start, and why there might not be local authorities joining up with local authorities, which by definition would be neighbouring, in such a way that they can provide joint services, and we can think of some circumstances where that would be sensible and does happen and probably already exists. So I think actually Stuart Stevenson's point may well be the fair one, that power already exists.
Well, I'm not sure if it does, and that's why I asked the question, because I think clearly at the moment we're focusing in 2 areas, between local authorities and the NHS. But what I'm thinking is that, and the Chair has alluded to that, is that sometimes there are clusters or hubs where it may well be beneficial for local authorities to be clubbing together in that way.
Yeah, okay.
Convener, the reason I respond in the way I do is because Aberdeen and Aberdeenshire already do a great deal of this. So I'm very familiar with my own area. And if... No, I mean, I'm not trying to shut the question down entirely. I'm merely saying that I can't identify from my knowledge of the local authorities in my... one of the local authorities in my constituency, what powers currently are lacking, because there is considerable joint working and joint arrangements.
Can I also say, I think the powers that we have to consider are the delegated powers within the scope of the bill,
well,
as it is before us.
Indeed.
Okay, and if it is restricted in the way which I think
Right,
it is,
okay.
then actually we can't, on the context of this report, ask that question because it isn't in the bill. But it is a perfectly decent question, which I'm sure the member would want to explore outside, and I'm sure the policy committee might just want to, or the subject committee might just want to consider whether all the options that should be available are available. I would suggest that's outside our remit and certainly within the context of this particular set of questions.
Okay, I'll take it up with the lead committee then, perhaps.
Right. Contrary to the exercise of the powers under section 1.6, which are proposed to be the subject of a negative procedure, the exercise of the powers of the ministers under sections 39.2a, d and e to specify the functions to be delegated to an integration joint board and other matters are not proposed to be subject to the scrutiny by Parliament. Specification of these matters by the ministers does not require to be made in a Scottish statutory instrument, nor is there provision for publication nor consultation requirements prior to specification. Does the committee therefore agree to seek an explanation as to why that difference of approach has been considered appropriate, as the powers under section 1.6, between the powers under section 1.6 and section 39.2? Thank you. Section 39.2c provides that on the failure of a local authority and health board to submit an integration plan for approval, ministers may require the authority and health board to delegate the specified functions to the joint board before the prescribed day, which is prescribed by regulations. Does the committee agree to ask the Scottish Government to clarify whether this provision is intended to be a power to prescribe a day, which is separate from the power in section 9.3, or whether it is only intended to refer to that power? Whether this could be clearer, given that section 39.1 and section 9.1 state that the sections apply to different circumstances, and it appears that the prescribed day is not defined by the bill, and if section 39.2c is intended to be a separate power, to explain the reasons for taking the power and why it is considered appropriate that its exercise is subject to the negative procedure. Section 40 enables ministers to give binding written directions to a health board, local authority or an integration joint board. In relation to the powers in section 40, does the committee agree to ask the Scottish Government to provide a full explanation of the reasons for taking these powers, which could be applied generally across a range of functions as well as to specific delegated functions, how the power to direct could be used, and the choice of direction as the appropriate procedure, and to explain in what circumstances this could introduce powers of direction by the Scottish Government over functions which are presently either not subject to such power or subject to direction by another authority, and why this would be appropriate.
Great.
Section 52.2 provides that the provisions of the Act, other than the general provisions in sections 49, 50, 52 and 53, come into force on such day as the Scottish ministers may by order appoint. Does the committee agree to ask the Scottish Government, if it is agreed that the effect of section 49 of the bill, read with section 30 of the Interpretation and Legislative Reform Scotland Act 2010, is that it is proposed that a commencement order under section 52.2 will be laid in Parliament and would be scrutinised by the committee. Section 49 proposes that an order making transitional, transitory or saving provisions for the purposes of or in connection with the coming into force of the bill is subject to the negative procedure, except where textual amendment to an act is proposed. However, section 49 also proposes that a commencement order made under section 52.2, which contains transitory or transitional provision or savings, would be laid, but not subject to further procedure. This appears to be inconsistent, as the parliamentary procedure will depend on whether the government chooses to make a commencement order or a separate power under section 51. B. Does the committee agree to ask the Scottish Government to consider that further? Thank you. Which concludes item 5 and brings us therefore to item 6, which is the Scottish Independence Referendum Bill. This item of business is consideration of the Scottish Government's response to the committee Stage 1 report on the Scottish Independence Referendum Bill. Members will have seen the briefing paper and the response from the Scottish Government. Do members have any comments, or are we content to note the response and, if necessary, reconsider the bill at stage 2? John.
I'm content, but I'm very happy to welcome the fact that they have taken cognizance of the comments we've made
Indeed.
previously. So I'd welcome it.
With that, thank you. That ends our agenda item 6, and I now move the meeting into private. Thank you.